Does she have a criminal history? She had some POMs from '97 and credit card abuse.
They would like to put that on the record.
Oh,
You know,
sure.
you studied the case.
Excuse me. Sorry.
Hoping you would reduce it to history. I will not. By the way, I mentioned it says hello. That's the best thing you said. For some reason, he thinks you have a gun. Sisters in the movies and George Lucas. Sister in California. Used to. So it's supposed to be law for that. So no brothers. Tell him not, and tell him to keep doing it, you know. The CPA put together a business team for the position. The key member is really the CPA. Because without an understanding of the structure of tax implications, everything's wrong. He should stay, he's a talented guy, he should stay. I'm not sure that my dad is so missing excitement that he'd take you up on that offer, but I'll tell him. You know, I always thought he should have stayed. I don't know if they'd ask him if that lady who was doing international, if he introduced me, was still there. I don't think I did. Oh, if she is. Maybe so. I'll ask him. But he's in Las Vegas. Yeah. I'll confer with Ms. Guerrero. You want to resolve it.
Ladies and gentlemen, if you can silence your cell phones.
I know it's not relevant, you
Make
know,
sure that
to
we
me,
just
it's
call your
relevant, it'd be
name,
different.
stand up, present
I had
yourself
another
on
stalking
here,
case
document
where
is not.
it
If you
actually
need to use
went to
your
the
cell phone,
house
you
and
can
knocked
call
on the
us
door.
afterwards. But just make sure you do present yourself, stand up, and say that you are here, not.
Just let me know what you need and I'll find a way to provide it to you.
Okay, what,
What is considering?
indicted.
Also, we are here for an inmate and they do come down. We ask that you do not speak to them in any way, shape or form, or we will ask you to leave.
All right, I'm going to call the docket. When I call the docket, you need to stand and let me know that you are present. Otherwise, I'm going to assume you're not present and a warrant may be issued for your arrest. Mark Anthony Guzman. Mark Anthony Guzman.
May I be excused, Your Honor, and if you need me, I'll come back.
Sure. Tamika Studemeyer. I don't know why this is on the docket. We shall see. Mariano Rendon. Alexander Rodriguez, custody. John Harold Robinson.
Present with counsel, we're ready on the motion.
Thank you. Ashley Medina. Ashley Nicole Medina, custody. Samantha Venegas.
I'm here, Your Honor.
Okay. Joseph Smith. Joseph Jefferson Smith IV. James McGarity. Could I see the file on James McGarity, please? Jenna Rodriguez. Jenna Lay Rodriguez. Araceli Robles. Could I see the file on Araceli Robles, please? Taylor Kirchmeyer. Taylor Yvonne Kirchmeyer. Shelby Jean Rodriguez. Cody Salazar, custody. Virgin Bonilla.
Here, Your Honor.
Millard Cummings. Millard Darrell Cummings.
Sir, your hat, remove your hat.
Clinton Dixon, custody. Ayana Hubbard, custody. Timothy Gonzalez. Are you Timothy Gonzalez? I'm sorry, I don't have my glasses on. All right, thank you. Have a seat. Gabriel Diaz,
Here.
Roberto Campos, Johnny Joe Aguirre, custody, Santo Carcamo, custody, Mary Stella Guerrero, Joe Manuel Hernandez, Brandon Trader, Brandon J. Trader, Freddie Ariano, custody, Rudy Gonzalez, custody, Jose Lopez, custody, Jose Amador, custody, Enrique Sariano,
Present with counsel.
good morning, Zion Taylor, Rudy Gonzalez, custody, John Hughes, John A. Hughes, Hews, Kelly Kotner,
Present with counsel.
Laura Salcedo, custody, Luis Mara, Jerwan Crawford, Oscar Garcia, custody, Briella Butler, Briella Sharan Butler, Seth McDonald, custody, and Christopher Morrison.
Here, Your Honor.
Thank you. Mark Anthony Guzman, Tamika Studemeyer, Samantha Venegas, Joseph Jefferson Smith, Jenna Rodriguez, Taylor Kirchmeyer, Millard Cummings, Brandon Trader, John or either Jonah Hughes, Briella Butler. All right, is there anyone who's present and your name was not called? Yes, what is your name? Brenda Carpenter? All right, thank you. If you'll pull that, please. Anyone else? All right, attorneys, we're going to start with closing arguments on a trial this morning at 9. So everyone, please confer, and the deputy will see if all of the jurors are here. They are? Okay,
And Judge, I did need to make a record,
yes.
if I could.
All right, yes, just give me one moment. Oh, you can stay at the table. Just a moment. All right, court is calling 2023 CR 4707, State of Texas versus Christopher Morrison. Can I have parties announced for the record for the state,
Megan Galloway and Andrew Edelman for the state of Texas.
for the defense?
Shannon Locke for Christopher Morrison.
All right, defense, it's court's understanding you have a motion.
Yes, Your Honor. So not yesterday, but Friday, the state asked one of our defense witnesses about a protective order. The state laid no adequate predicate for tying that protective order to Mr. Morrison. They had the protective order prior to her testimony and didn't disclose it to us. They have an ongoing duty to disclose information, whether it's inculpatory or exculpatory. I had the right and and frankly, we had the opportunity, we should have had the opportunity to evaluate that before the state began cross-examining our witness about that. And when they failed to disclose that unsigned, ungranted, I think it was a dismissed protective order, they should have at least provided it to me so I could evaluate it to determine whether or not that was something that I could proceed forward with or not. So I would ask that the jury be instructed not to consider that protective order, and I think that it's grounds for a mistrial.
All right, thank you. State.
Judge, The reason that the protective order even came into evidence is because Mr. Locke made the trial strategy decision to call a witness to testify to his client's peacefulness. That is information that was within his client's knowledge, and it was brought in as a rebuttal. And so it has been since turned over to him, and so we would ask that you deny his motion from this trial.
All right. And so we can go off the record. If y'all want to do your research on your case law, I would suggest looking at Jaubert, Jaubert v. State, 74 Southwest Third, and also Smith v. State. So while you all look at that, if you want to argue some more after reviewing those two cases, I'll let you argue and then I'll make my ruling.
I didn't have the full citation for Joe.
It's 74 Southwest Third, 1-4, pages 1 and 4, Texas Criminal Appellate Court, 2002. And also, if you want to look at Gillette, Gullatt v. State, 590 Southwest Third, 2026. And that's from Texarkana, 2019, but that case cites the Jaubert case. All right, attorneys, you know the rules. If you have a case that you are ready to proceed on, just have the clerks pull it. Hello. It's not showing. Now, thank you. Thank you so much. I'll call you when we are. All right, thank you. Oh, I should have asked them. State Defense, are you all going to need this card?
Judge, I plan on using it.
All right. Oh, let me know when y'all are ready. because
I'm ready,
the
Your
doors
Honor.
are ready.
So I glanced at the Joubert case and I understand the concept, but here.
Oh, you can remain seated.
Thanks, Judge. Here, it is a little bit different. We had a pretrial hearing. We had not a pretrial hearing, but we had a pre-testimony hearing where the state had this information. They have an on-duty, they do have an ongoing duty to disclose. And while I understand what Joubert is saying, that in their case in chief, but they still can't lie. It doesn't give the state the ability or the right to lie in wait with this information.
Well, so you do agree that one, it was done as rebuttal. Do you agree to that defense?
Yes, Your Honor.
All right. And you do agree that it was admissible as rebuttal?
I don't know that it was, Judge. I don't, because it was never tied to Mr. Morrison. They never went through the predicate of tying it to Mr. Morrison. Had they tried to admit the protective order, that would have been one way to do it, but they have not tied. All they did was ask questions about an affidavit that was never tied to Mr. Morrison.
Okay.
So I don't know that it is admissible under those scopes. They have to make it somehow. I can't just make up an affidavit and read it to the witness and ask if they know about it. There needs to be more than that. I was making objections throughout their cross. So They
Your
did,
objections were not to foundation,
it was,
not
was
to
a-
foundation. Am I correct in that?
that's correct, yes, Your Honor.
All right, state.
Judge, pursuant to Jalbert v. State and Gullett v. State, it's the state's position that they were not entitled to evidence, or notice of that evidence because it was used in rebuttal in response to his testimony for his, defendant's character for peace.
All right. So to solve the issue, the court could give, I don't know if in the charge, if there's any instruction on extraneous.
There is, Your Honor, yes.
Well, would there be a different instruction you request, Mr. Locke, other than the extraneous instruction that's currently in the charge?
Yes, Your Honor, I'd ask that the jury be instructed to disregard any, they didn't really hear any evidence tying the protective order to Mr. Morrison. And so I would ask that they be instructed to disregard you have heard allegations that there was a protective order. That protective order was never, tied to Mr. Morrison. Therefore, that line of questioning should be disregarded, I think would be the appropriate instruction.
State.
Judge, during the questioning, it was regarding whether the witness was aware that the applicant applied for a protective order. I don't think I ever made the representation that one was granted. And so we don't believe that it was in rebuttal, so we don't believe that he was entitled to notice regarding that. It's a response to his own testimony regarding his client's peacefulness.
All right. All right, we can go back on the record. One, the court notes that there's already an extraneous language in the charge. The court will add to the charge that attorney's questions are not evidence. That's what the court proposes to add to the jury charge. Any objection to that being added to the charge? State? Defense, any objection to that being added to the charge?
I don't object to the additional language, but my objection to the jury's ability to consider that evidence remains.
All right. All right, that'll be denied.
And I would also ask for a mistrial, Your Honor.
All right, that'll be denied. All right, I'll have that added to the charge.
To the extraneous evidence,
Well, the extraneous is already added. What I'm going to have added to the charge, since both parties said they had no objection, was to remind the jurors that attorney's questions are not evidence.
will you add that to the extraneous evidence charge?
Where do you want it placed?
I would like it in the extraneous evidence charge.
What specifically do you mean of you want it in the extraneous charge?
But where we have the extraneous evidence,
Page 10?
yes,
All right,
you'd either add it to the beginning or to the end.
okay. All right, that can be done.
Thank you, Your Honor.
Judge, I would request the same.
And the court's gonna read the instructions first, Your Honor, before we close.
Computer systems are down. So that is the lateness. It's not due to any of the attorneys or persons not being where they were supposed to be. So what I'm going to do now is I'm going to read you the charge of the court. You don't have to memorize it. You will have the original back with you when you begin your deliberations. Charge of the court, members of the jury, the defendant Christopher Morrison stands charged in counts 1 and 2 of the indictment with the offenses of aggravated assault with a deadly weapon alleged to have been committed on or about the 3rd day of June 2022 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. 2, a person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 3, our law provides that a person commits the offense of deadly conduct if he recklessly engages in a conduct that places another in imminent danger of serious bodily injury. 4, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct when he is aware of the nature of his conduct. A person acts knowingly or with knowledge with respect to the circumstances surrounding his conduct when he is aware that the circumstances exist. You are instructed that a person acts recklessly or is reckless with respect to the circumstances surrounding his conduct or the result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6, count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did use or exhibit a deadly weapon, namely a BB gun, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Christopher Morrison did intentionally or knowingly threaten imminent bodily injury to Jesse Izagiri by shooting at or in the direction of Jesse Izagiri with said deadly weapon, then you will find the defendant, Christopher Morrison, guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider any lesser included offenses under count 1 as instructed in paragraphs 7 and 8, but skip to paragraph 9 to consider count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and proceed to paragraph 7 to next consider whether the defendant is guilty or not guilty of the lesser included offense of deadly conduct under count 1. 7, lesser included offense of deadly conduct under count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did recklessly engage in conduct that placed another, namely Jesse Izagiri, in imminent danger of serious bodily injury by discharging a BB gun at or in the direction of Jesse Izagiri, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of deadly conduct under count 1, and do not consider paragraph 8, but skip to paragraph 9 to consider count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of deadly conduct under count 1, and next consider paragraph 8 to decide whether the defendant is guilty or not guilty of the lesser included offense of assault under count 1. 8, lesser included offense of assault under count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did intentionally or knowingly threaten imminent bodily injury to Jesse Izagiri by shooting in the direction of Jesse Izagiri with a BB gun, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of assault under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of assault under count 1. 9, count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did use or exhibit a deadly weapon, namely a BB gun, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Christopher Morrison did intentionally or knowingly threaten imminent bodily injury to Michael Izagiri by shooting at or in the direction of Michael Izagiri with said deadly weapon, then you will find the defendant, Christopher Morrison, guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and do not consider any lesser included offenses under count 2 as instructed in paragraphs 10 and 11. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and next consider paragraph 10 to decide whether the defendant is guilty or not guilty of the lesser included offense of deadly conduct under count 2. 10, lesser included offense of deadly conduct under count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did recklessly engage in conduct that placed another, namely Michael Izagiri, in imminent danger of serious bodily injury by discharging a BB gun at or in the direction of Michael Izagiri then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of deadly conduct under count 2, and do not consider the lesser included offense of assault as instructed in paragraph 11. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of deadly conduct under count 2, and next consider whether the defendant is guilty or not guilty of the lesser included offense of assault under count 2 as instructed in paragraph 11. 11, lesser included offense of assault under count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did intentionally or knowingly threaten imminent bodily injury to Michael Izaguirre by shooting in the direction of Michael Izaguirre with a BB gun, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of assault under count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of assault under count 2. You are instructed that questions by the attorneys are not evidence, and you are not to consider any question posed by the attorneys in direct or cross-examination of witnesses as evidence. In this regard, if there is any evidence before you regarding the defendant having committed offenses or acts of misconduct other than the alleged offense against him in the indictment in this case, you cannot consider said evidence for any purpose. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Off the record for a moment, you need to remove your hat. Back on the record. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict as to each count independently, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict on each count, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be on each count, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by your presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
Please, the court.
Yes.
Apologies. This is a deadly weapon. A deadly weapon is one that is capable of causing death or serious bodily injury. A deadly weapon is not a weapon that is capable of causing death or serious bodily injury in every conceivable scenario or every possible circumstance. It's just a weapon that is capable of causing death or serious bodily injury. Pendleton testified that after testing this weapon, he concluded that this is capable of causing death or serious bodily injury. But even if you discount Pendleton's testimony and his conclusion, this weapon did this to this sliding glass door. The weapon that did this could do similar to a human being. That's a deadly weapon. Now, Christopher Morrison fired this weapon
at or near two people. There was testimony that Mr. Morrison is well-trained and experienced in the use of weapons, both firearms and possibly of this type. If Mr. Morrison is so well-trained and experienced, what can we conclude from him firing this weapon at or near two people? The answer is that he either intended to cause them imminent bodily injury, or he knew or should have known that firing at or near them could have or would have caused them imminent bodily injury. That's a threat. A threat that Mr. Morrison either intended to make or knew or should have known that he was making. That's assault. Assault committed with this deadly weapon is aggravated assault with a deadly weapon. That's what Mr. Morrison is guilty of committing. Thank you.
Defense?
May it please the court,
Yes.
counsel for the state. Good morning. I told you at the beginning of this case, it was an honor and privilege to represent Christopher Morrison. It really is. It really is a privilege. It really is an honor. An honor, frankly, that I might not be worthy of. Served this nation. And now I get to advocate for him as we use the rights that he fought so hard for. I also told you this was an American tragedy. An American tragedy. How we ask so much of our veterans, and we're so quick to throw them away. That's what this case is also about. You can't deny that. Very sad. It's 2.5 years for evidence. Morrison has used that time. Come back from the dark place that he was and build a life, a really good life in Indiana. Actions of June 3rd, 2022, not something he's proud of. Very sad about it. Very sorry. Didn't commit these offenses. Didn't commit the offenses that the state is alleging. He just didn't. He didn't. And state, frankly, when it comes up here, it really doesn't describe the testimony accurately. Why is that? Why don't they describe the testimony accurately? You heard their expert witness. Let's see the date of that report that he filed. It's more than a year old. And they could have asked the questions that I asked. Questions that establish that Chris is not guilty of this offense. The big offense that they allege, the aggravated assault with a deadly weapon. He's just not guilty of that. Okay. In the laboratory, that BB could go 315 feet per second. How fast could it go that day? I don't know. Was it a deadly weapon the way Chris used it that day? I don't know. If he doesn't know that in its use and intended use, it was a deadly weapon, how can you? You haven't heard anything else. So he testified, their expert witness that they called testified that he didn't know. That is a reasonable doubt. It is a reasonable doubt that came directly from their testimony. Absolutely. In our instructions, it says that the presumption of innocence alone is sufficient to acquit him. And that's what we have. We have a presumption of innocence and their witnesses saying that they don't know. What else didn't they know? I asked Izzy, Officer Izaguirre, I asked him, did you ever find out what landed in the pool? No, I don't know. I don't know. That's what he said. You have these BBs. Remember, he describes, you can open these up and you can feel one of these BBs, how light they are. He describes a splash that goes over his head. that wasn't a PB. It just wasn't. So that's a reasonable doubt. Were those splashes, could they have possibly been caused by these BBs? We don't know. The state didn't prove that. So Mr. Morrison is not guilty of everything. You should go through the verdict forms, go to that second line, and sign the not guilty verdict on each allegation that the state has made. But let's go through step by step. Let's go through step by step. And so the state does bring up the sliding glass door. How did that happen? What did the state prove to you? Did they arrest Mr. Morrison for that? They did not. Go to your exhibit for your instructions, page number 10. Go to page number 10, and it says anything that he's not accused of, you shouldn't consider it. They are also asking about a protective order from his girlfriend. They asked her about that. She had no idea about that. Why would they do that? They never tied it to him. Not once, not with any piece of evidence or information. No date of birth, no case number, no nothing. You can't consider it because he's not accused of it. So you have to take the sliding glass door out of your deliberations. You got to take the protective order out of your deliberations because they're just irrelevant. That's what the instructions say. So then we look at the different allegations. And it starts on page 6, paragraph 6, I'm sorry. And there's the big one, the aggravated assault with a deadly weapon. So for an aggravated assault with a deadly weapon, you have to really believe, that he was trying to kill the people in that pool with a BB gun. Now remember, they're expert. Is this a deadly weapon? I don't know. In the manner of its use, intended use that day, is it a deadly weapon? I don't know. That's a reasonable doubt. Have to find him not guilty of that. Because he did not intentionally, there's no evidence that he was intentionally trying to kill or seriously injure or maim the people in that pool. Gail and Izzy. So we go to the next thing. And the next one is the deadly conduct. Okay? So here we have recklessly, and recklessly is like you disregard a substantial risk. That's reckless. And I do think, right, okay, that shooting the BB gun in this apartment complex is probably a reckless act. Not an intentional act, not a knowing act, because he's not trying to hurt or kill those people, okay? But reckless, okay. So maybe they can clear the bar on reckless, but again, they have a problem. Because it has to be in danger of serious bodily injury. Can this cause serious bodily injury? This BB gun, it has to hit your eye at a very specific speed. Was it going that speed that day? I don't know. Where else could it hit? If you hold it 3 to 5 feet away from your chest, it could cause serious bodily injury. But we know that that wasn't the case. That's not what happened that day. Other than that, you know, if it was, I don't know. So could it have caused serious bodily injury using the BB gun? The answers are, I don't know. That's a reasonable doubt. That's a reasonable doubt. And you have to acquit Mr. Morrison. So then finally we have intentionally or knowingly. So that means that he's trying to scare the people in the pool. Okay, and there's a part of Jesse Izagita's testimony where he said that he was looking around in the balconies and he sees somebody and they make eye contact, and he identified Mr. Morrison, and they make eye contact, and Mr. Morrison's surprised. Like he's surprised to see somebody in the pool. He's describing a surprised reaction. There's no evidence that Mr. Morrison knew that there were people in that pool, that he saw them, or that he was trying to target them. He wasn't threatening them. He didn't want to hurt anybody. And that is the consistent evidence throughout the case. So we have this testimony. We have these officers. How did we get here? How did we get here? there were some very important discrepancies in the state's case. Very important discrepancies. First, we had Detective Rodriguez come up. And she couldn't tell the same story twice to save her life. She constantly changed. How many times did you talk to Jesse Izagide? Once. I talked to him once. Except when I called him on the cell phone. Okay. And we had a detailed conversation, and that's where I found out. And then I talked to him by the pool after I turned my body cam off. There were 3 conversations. Why is that important? Because she's giving all this detail. She's giving all of this detail, right? But none of it's captured on her body cam. Why did she turn her body cam off? And then see everything that was important that happened after that and describe it. Why didn't she turn her body cam back on? Oh, she did when she was going to approach the apartment, but not until then. Be very skeptical of her testimony. Detective Izagide or Sergeant Izagide. Do you know Detective Rodriguez? In passing, we know in passing. We're members of the same department. Everybody kind of knows each other. Detective Rodriguez. No, Sergeant Izagide? Yes. I have a nickname for him. His name's Izzy. We were part of the same class. We're part of the same class. That's incredible. Those are important discrepancies. You cannot then take what they say at face value. You have to be skeptical because they've been shown to be honest many times. So then you got Pendleton. He comes in. He very clearly says that on the day of the offense, he does not know that this thing would have to be very close to the chest, cause death or serious bodily injury, or actually hit an eye at a very specific speed that he couldn't establish going at that on that day. That's reasonable doubt. And we had our witnesses testify. We had our witnesses testify. And you found out about Chris Morrison's service. You found out about his service. Found out that he's been going out on hundreds of missions. He is an expert marksman. That Shiloh Harris, who goes on these missions with him, who went day after day, was willing to put his life in his hands based on his ability to shoot. More evidence that Chris did not intend to threaten or hurt or scare anybody. You heard his girlfriend come in. She testified that he's a gentle guy. And the state, they ask about some protective order. She had no idea about that. She hadn't heard anything about that, and it didn't sound like anything to do with Chris. Did they ever tie that to him, and why didn't they? And then instruction number 10. Instruction number 10 says, if he hasn't been accused directly of this, can't consider it. That's the sliding glass door, and that's the protective order. Those 2 things. For 2.5 years, we've been protecting Chris. So he could get his life together, so he could get himself established and in a good spot. He's there. He's used that time to do what he needs to do, make sure that he's not in that dark place that he was at on June 3rd of 2020. He's used that time well. We're now handing him over to you. Handing him over to you. This morning, last night, I always toss and turn jury trial. And I think to myself, well, what happens if
2 minutes.
I don't make the right argument? Thank you. What happens if I don't make the right argument? What if I say the wrong thing? Last night, as I was thinking, I did think about 12 of you. Come together, strangers, come together in our free country, protect somebody who has fought for our freedom. Thank you so much for letting me do this, Bruce. Thank you. It has been an honor and a privilege. It really has. And I can only hope As I did go to sleep last night, I was comforted by the thought that you all will follow your oaths. But find him not guilty. Thank you very much for your service. Thank you.
All right, state, yes.
For some reason, I thought, what's the big deal? It's a BB gun. Ladies and gentlemen, the big deal is that this BB gun, State's Exhibit number 12, is a deadly weapon. And you all heard testimony from David Pendleton saying so. Their own witness, Mr. Harris, said that State's Exhibit number 12 could cause serious bodily injury. That is what makes it a deadly weapon. What also makes this a big deal is that it was fired at Jesse Azagita and his 3-year-old son. Now I want to talk to you about the mental states. We talked about this in jury selection. You're not required to read the mind of the defendant. You can infer this from his actions and the circumstances surrounding. Now let's talk about recklessly. It's a conscious disregard of a substantial and unjustifiable risk. At a minimum, the defendant acted recklessly. His own defense counsel just conceded that to you. Now, let's think about this. The defendant has expert knowledge regarding firearms due to his military experience. He has expert knowledge of gun safety, and so he knows that there's a big risk if someone is hit by that BB. Now let's talk about knowingly. Aware of the nature of his conduct. Did he know what he was doing when he did it? I submit to you, yes. And how do we know this? He was aware that he was shooting the air rifle into the pool and into the window of apartment 303. He's aware that he lives in an apartment complex, that there's multiple people that live in that apartment complex, and that the pool is a public area where multiple residents frequent. Yet he's shooting upon it. And he was aware that Jesse and Mikey were in that pool. Now, what makes intentional in this case? What other reason would he be firing into a pool of 2 individuals? Because it was his desire, his marksman desire. This goes back to what we talked about in the Titanic, when Cal is firing upon Jack and Rose. What was his intent? Now we talked about in jury selection, testimony is evidence. So let's talk about the witnesses that you all heard from. You heard from David Pendleton, who's been with the crime lab for a number of years. He testified that State's Exhibit number 12 is capable of causing serious bodily injury. And how does he know that? Because the velocity necessary to cause serious bodily injury is 246 to 249 FPS. The velocity of State's Exhibit number 12 was between 315 and 337 SPS. That is way higher than what is necessary. State's Exhibit number 12 is capable of causing serious bodily injury. We have heard testimony from 2 witnesses that concede to this. And that is what makes it a deadly weapon. Now, defense wants you to believe that the velocity was inaccurate, that it was lowered by the weather, that the velocity was lowered by the distance. Let's look at the evidence. This is the pool from the defendant's apartment. This was the pool from the defendant's apartment, and you can clearly see people. Okay, so this notion that he wasn't aware that someone was in the pool is a fallacy. This is the view of apartment 303 from the defendant's apartment. And this is the velocity of State's Exhibit number 12 illustrated. 315 to 337 SPX.
I'm gonna object to This is extraneous evidence that the jury should not be considering. It's improper closing.
All right, ladies and gentlemen, you will remember the evidence as it's been presented to you. You may proceed.
Now let's talk about the testimony that you heard from Jesse Izagita. Jesse Izagita testified that he overheard harsh splashing 3 to 4 times within arm's length of him. And this put him on alert. When he heard the window shatter, it was at that point he believed that somebody was firing a gun or a pellet gun. And at this point, he decides to take Mikey out of the pool. Once he heard the racking of a firearm, he was sure of what was going on. So sure that he decided to put his 3-year-old behind a pillar for cover. He observed the defendant laying in the prone position on the balcony of apartment 251, which is the same apartment that officers made contact with this defendant. Jesse Izagita testified that his fear was on level 10. And this is something that defense attacked because he's a police officer and he serves our community every single day. Why would he be on a level 10? Because he has his 3-year-old with him. He was in such fear that he reached for his duty belt, and he testified to this on the stand. He reached for his duty belt because he was going to retrieve his weapon and fire in return. That's how scared he was. He was in fear that he was going to sustain imminent bodily injury. And he has no reason to lie. Everyone testified that the defendant and Mr. Izagita had no prior interactions with each other. So what would he gain by making this story up? Absolutely nothing. And the evidence is consistent with his statement regarding hearing the window shatter and the racking of the gun that was found in that defendant's apartment and apartment 303 that is right across the way. Now let's talk about Detective Rodriguez. Ultimately, her conclusion was that she believed that the defendant fired upon Jesse and Michael Izagita. And there's the evidence that was to suggest that was Detective Izagita or Sergeant Izagita's testimony, right? His statement, the cracked window, the BB gun, and the defendant's own admission that he was firing the BB gun. Now, Detective Rodriguez did testify that the defendant made an admission of shooting into the pool to Officer Ashby. But according to defense, that's not a good admission because they want you to believe that when a defendant tells someone what they're arrested of, that's not an admission. It is. It is. And why else would he say it if it isn't true? Now let's talk about the defense witnesses that you heard from. Mr. Shiloh. Even he testified, State's Exhibit number 12 can cause serious bodily injury. He also testified to firearm safety rules that we all know, which is you treat every weapon as if it's loaded. You don't aim unless you're ready to shoot. You never put your finger on the trigger unless you're ready to pull it. And then he made some mention about flagging. You know, I'm not a trained expert in firearms, but when I took it out of the bag, the barrel crossed him. And it made him so uncomfortable that he had to, you know, bring it to everyone's attention that I did it. Well, imagine how, you know, Jesse and Michael felt when they were being fired upon. That is something much more serious than a firearm that's been made safe in a courtroom, me, you know, displaying it to him. And regarding Ms. King's testimony, she testified back in 2022, she wasn't really that close with the defendant. And I submit to you all that she doesn't really know him as good as she thinks she does. Now, during your deliberations, you are solely deciding guilt, innocence. That is what the defendant is charged with in the indictment and what you will receive in the jury charge. On or about June 3rd, 2022. That is not in dispute. You've heard testimony from multiple witnesses saying that that's the date the offense occurred. In Bexar County, Texas, that's not in dispute. The defendant, that's not in dispute. Did use and exhibit a deadly weapon. That's not really in dispute. You've heard testimony from multiple witnesses that that is a deadly weapon because it can cause serious bodily injury. Did intentionally or knowingly, I've already made my arguments regarding that, and threaten imminent bodily injury. You all are gonna be able to take those BBs back there, those metal BBs, and you can decide for yourself. What are not defenses to this indictment is whether a 911 call was purged, whether the detective had continued contact with the victim on the day that she made the location to take his statement, whether the detective has a working relationship with the victim, or whether there were no BBs located in the pool. Ladies and gentlemen, use your common sense. Pools have filters. They have multiple filters, and the police didn't go out to conduct their investigation until the next day.
2 minutes.
There was no chance of them finding those BBs. That does not mean that the offense did not occur. We cannot hold these things against Jesse Izagita, and we surely cannot hold them against Michael Izagita. Now, you're instructed to not let bias or sympathy play into your verdict. And so we talked about this in jury selection. If you believe he needs help, or you feel sorry for him, or he was having some type of mental health or substance abuse issue at the time, those are things that you consider in punishment. You do not consider them in your deliberations right now. You all swore that you would render a verdict true according to the law and the evidence. What makes an aggravated assault with a deadly weapon? The defendant threatening Michael and Jesse with imminent bodily injury and using or exhibiting a deadly weapon during that threat. While this defendant is guilty of the lesser included offenses, the more appropriate charge is what is charged in the indictment, and that is aggravated assault with a deadly weapon. Ladies and gentlemen, there's an opportunity for justice to be had today, and it's up to you. You all decide when he gets that BB gun back and when he can fire it again. And so I ask you to find him guilty of the offense of aggravated assault with a deadly weapon.
All right, ladies and gentlemen,
Everything goes through the judge. I don't reset cases, I don't, everything, we put your file up there, she'll call you up in just a second. Thank you. It's not set in the system.
He has an ATR.
Yes, I asked another officer.
Louise?
Yes, yes.
Thank you.
All right, everyone, the rules are still the same. If you want to approach the court, just have them pull your phone.
Maybe those two that.
Busy today.
All right, Mary Guerrero. Who's the attorney? All right, Ms. Guerrero, if you'll come forward. Hello. Good morning. Good morning. All right, counsel, was an offer tendered?
Offer was tendered, it's not acceptable. We need to see more discovery. I'm gonna get a USB here, come back and give it to the prosecutor. for
All
more
right,
information.
Ms. Ferguson. On Guerrero, I need 1 month reset for plea deadline dates.
I can do January 14th.
All right, January 14th.
Okay, thank you.
Once you
Thank
sign the reset form, you are excused. And thank you for dressing
Yes, ma'am.
appropriately for court.
Yes, ma'am.
Thank you. Samantha Venegas. All right. All right, Deputy, could you make an announcement for Samantha Desiree Venegas? Thank you. And counsel, I do believe that the bondsman may have filed an affidavit to surrender surety. I'm unable to check because the system is down. We're going to go on the record. Court is calling 2024 CR 008052. And 2024 CR 008054, State versus Samantha Desiree Venegas. Could I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense?
Denny Callahan, not ready, not present.
All right, so this hearing was actually scheduled for an agreed bench trial today. Deputy? She hasn't made it back. The court is aware that I believe an affidavit to surrender surety was filed. Is that correct?
I don't know, Your Honor.
Okay. The court is unable to check due to the system Odyssey being down. Deputy, did you make the announcement?
But he answered outside, Judge.
All right, thank you.
You're welcome.
All right, state, what are you requesting?
Grant the affidavit of surety to surrender issue the apprehension of the defendant.
All right. And again, the court believes an affidavit to surrender surety has been submitted, but our systems are down throughout the courthouse, so I'm unable to check.
And Your Honor, I apologize for interrupting. If there is an affidavit of surety to surrender, then grant it.
Okay, so what I'm going to do is I'm going to issue a judge's warrant and remand her without bond.
Yes, ma'am.
All right, is there anything else, counsel?
No, Your Honor.
All right, you're excused.
Thank you, Your Honor.
All right, anyone else ready? What's your case? All right, did you ask them to pull it?
I did.
All right, have you all pulled Ashley Medina? All right, Ashley Nicole Medina.
She's in jail, Judge.
All right, was she on the docket today? All right, so where is she?
They didn't bring her over, Judge.
Let me find out what's going on.
It might be because she just came back Friday.
Okay,
2497.
we're gonna find out. That way we'll know.
187 is Richard Casanova. Richard Casanova.
Who's the prosecutor on Ashley Nicole Medina? It's criminal trial division. On this one, where are we on the blood discovery?
Yes.
I think it came in the, looking through their file. It came in, right?
I need to check.
It looked like it was in the file, Judge.
Okay. All right, let's see.
Want me to get your file?
Do you need the cause number? Okay. Yeah, I think the system is still.
It came in, Judge. I just didn't look at it that carefully, but
All right, so you have it?
I have it, yes. I mean, it's in their file.
Oh, you have the blood discovery.
I saw it in their file. But I don't have it with me, but it's in their file. Yes, looked like they had it.
All right, let me,
And it sounds like he needs a copy of it, and then, so I will check.
all right, well, let's make sure it's there.
Good morning.
Good morning. Odyssey's down.
What's that?
Odyssey's down.
It is. I don't use that.
Yeah.
Judge, I wanted to, I know Venegas that I just found out did not show back up. Because if I tell them the release, then do you want me to stay? Okay.
Because she didn't show, so I issued a warrant, and I think since it's 10:30, she would have been.
Yeah, it's okay. Thanks, Judge.
My understanding, I haven't been able to go online. My understanding is that the bondsman did an affidavit to surrender surety. So,
That's what Mr. Guy said. Okay. Well, I'll run back, let release them, I'll come right back.
all right, thank you.
I'm setting.
Sorry, I'm trying to. I don't have a setting here. She has a feedback case. That's.
It's not. Quite frankly, given what we have, I think.
Yes.
So I've had a chance to look at the physical found, it looks like we do have only toxicology reports, but not the data, the support staff. Which we want blood discovery.
And how long do you think that will take?
Judge, I would request that. Before you
Even if I do.
All right, and do you know what happened with Ashley Medina? All right. All right, Norm, I need a 45-day reset on Medina for blood discovery. This will be the last setting for blood discovery. If it's not here, then whoever needs a subpoena will need to come because this has been going on since October. All right, we'll come back on January 30th. Is that a good day for you, counsel?
I hope so, Judge.
2025.
Hmm.
Yes. Anything else?
No, Judge.
All right, thank you.
Thank you.
Who's here on Mariano Rendon? All right, who is, are you going to be arguing this?
Yes, Judge, yes.
I don't.
I'll let you do that and just let me know when you're ready.
Make sure you speak on it first.
Yes, ma'am.
Very good.
All right, we're going to go on the record. And 2024 CR 2338B and 2024 CR 2339B, State versus Mariano Rendon. Can I have parties announced for the record for the state?
Megan Galloway for the state of Texas.
Larry Bloomquist for the defense.
All right, we're here. The court received a request for a travel permit from pretrial services. The defendant is requesting to go to Vegas from December 30th, 2024 and returning on January 2nd, 2025. State, do you have objections?
Judge, so just we would request specific conditions with that. So a UA before departure and upon arrival, as well as prohibited possession of firearms.
All right, when you say UA upon arrival, you mean return?
Yes, yes, arrival and so return to San Diego.
All right, do you have any objections to that?
No, Your Honor, and I will just let the court know he did travel one time before for business. We did a UA when he came back and he was clean. I have no doubt that he will remain so.
All right. All right, then the court will grant the request. There's to be a UA completed before you leave and a UA upon return. Do you understand?
Yes, Your Honor.
All right, is there anything else?
No, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome. Yes.
Mr. Beck, I don't know how we got there, but I believe that belongs in your file.
Ah, thank you.
That's fine. That's fine.
Enrique Soriano.
Present with counsel.
All right, so have you received the blood discovery?
I got the, this is what we've received today, video dash cam. And then in terms of the laboratory diskettes, we don't have that yet. I went by the window this morning. It's not there, but they are
All right,
providing.
so where's the blood discovery?
That is.
Is this the dash man?
No, this is the blood discovery.
Okay, so the dash cam is the one that we were working for. I thought that's what this was.
No, the last time you all were here in August, my understanding that both parties agreed that there were no dash cams available. That's what the court has in its notes.
Is that
So there's-
correct?
As far as I'm aware, yes.
So State, were you able to tender an offer? All right, Norma, on this case, set it for a plea deadline date in 30 days, please.
February 14th.
All right, January 14th is going to be your plea deadline date. You need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your case will be set for jury trial.
All right.
So
good.
you get the reset form from the coordinator, and once he signs the reset form, he's excused.
Yes, ma'am.
All right, thank you for dressing appropriately for court. You always do, though.
My pleasure, Your Honor.
Thank you. All right, if you'll just have a seat and they'll bring the reset form to you.
Thank you.
Kelly Cotner.
Just have to.
On this case, blood discovery in?
No. You have it?
I think that's incorrect. I think it's already provided.
All right, so yes, I have in my notes that blood discovery was received on November 18th. And the state was to tender an offer today.
Wait a minute. The diskettes have been given to me?
If I'm informed correctly, yes.
I don't have it in my file.
All right, he doesn't have it in his file. If you have a copy, if you could give him another copy.
And
And
I've been
then-
looking for the diskettes at the window. I mean,
All right, they have it, so you'll have it, but I have it as being tendered on November 18th.
okay, now there's an additional issue
Yes.
regarding
If I recall correctly, I believe ADA Crespo is working on getting those from Universal City.
All right, can you call him and see what the update is on that?
I can call her. I don't know if she's gonna pick up.
All righty, we shall see.
Judge, the motion that we filed was more encompassing than that. We want to know not only the status of his cases, but if there's any cooperation agreements that he's having with,
Well, I can't answer your question until they tender what they have to you, or if they think it shouldn't be tendered until I do an in-camera inspection. So I don't have it.
well, okay, then just, I didn't want to limit it just to,
Mhm.
okay, very good.
All right, so this is what I'm gonna do. I'm resetting this for January 14th. The disciplinary records need to be here in my possession, or either the person who has access to that needs to be here explaining why they don't have it. All right, Norma, if you recall this for January 14th, please.
And then I guess the diskettes for blood, I'll have to check on that because we don't have it.
Your Honor, I think those might be these,
What, the blood discovery?
this little folder that says Kelly Cotner Blood Discovery.
Okay. All right, there you go.
Okay, then I'll pick it up from them now.
All right, thank you. All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Yes, ma'am, thank you.
All right, you're welcome. John Roberson.
Yep.
Who's the attorney on John Roberson?
It's me, Judge. Okay.
You got it.
All right, my understanding that you was gonna file a motion with regards to jurisdiction.
I did.
Okay,
You don't have it?
no, I haven't. I just was stating what we're here for.
Yes.
All right, State, did you receive the defendant's motion to set aside the indictment based upon jurisdiction?
I did, Your Honor.
And have you had a chance to review it?
I have, Your
Are you in agreement?
Honor. No, Your Honor.
All right, court is calling. Are you ready to proceed on the?
Ready?
Court is calling 2024 CR 006-935, State versus John Roberson. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
George Sharman on behalf of the defendant.
And are you Mr. Roberson?
Yes, ma'am.
All right, the defense has filed a motion to set aside the indictment. State, are you prepared to proceed?
Yes, Your Honor.
All right, defense, it's your motion.
Judge, basically, the line is that one of the enhancements that the state is using is a misdemeanor from Travis County. And the defendant, after he served his probation on it, was granted a pardon in 2004 as to that. And as a consequence, it's not a case, a judgment for purposes of enhancement of punishment because of the pardon. And the case that states that is Cuellar versus State.
Well, have you submitted any evidence to show? that he was pardoned?
There are attached exhibits to the motion. And these were the exhibits that were given to me by the state. And if you look at Exhibit 2, the language in Exhibit 2 says that the case was dismissed. And under 4212 Section 20, back in that period of time, the judge allowed him to withdraw his plea of
But
guilty.
let me ask you this, because I'm reading the order discharging defendant from community supervision. Is that the exhibit you're speaking of?
The one marked, yes, Exhibit
All
2.
right, so what it says in exhibit number 2 at the end, it says that he's released from all penalties and disabilities resulting from the crime of offense, except that proof of said conviction shall be known to the court should the defendant again be convicted of any criminal offense.
He has not yet been committed. He has not been convicted. Not only that, the case is dismissed. It's ordered dismissed. And under the Cuellar case, if you read this, and I'm tendering you a copy.
Oh, did you tender a copy to the?
Yeah, I also gave them notice of that under this section of the Code of Criminal Procedure, whenever a judge goes through this pardon situation, that it can't be used for enhancement. So, and this is a copy of the Cuellar case that talks about it.
All right, state.
Defense counsel would have a good argument if he was right, but he's not. Because of the language of 42.12 Section 20. In subsection B, it states this section does not apply to a defendant convicted of an offense under sections 49.04 through 08 Penal Code. Those are the DWI provisions of the Penal Code. So now we have a philosophical problem. If a judge issues an order that the judge lacked the authority to make, has the judge in fact issued an order? And the answer, as far as I can tell, is no. In Ray State ex rel Hilbig, several defendants and real parties in interest were convicted of DWI felonies and were sentenced to regular probation. After completing their probation, Judge Hilbig terminated their sentence, set aside the judgments, and dismissed the indictments. The state argued that the judge had no authority to terminate the probationary periods under Article 42.1, Section 20 at the time. And the Court of Appeals of San Antonio agreed because the language of the statute means what it says. 49.04 offenses are excluded from the judicial clemency provision. Additionally, in Bradley v. State, which is admittedly not a published report, the Dallas Court of Appeals in 2002 came to the same conclusion on roughly the same facts as this. When a judge issues an order that the judge had no authority to make, we treat it as a nullity. We ignore it, which means judicial clemency was not granted for purposes of this motion to quash, and it should be denied.
Judge, he's referring to the 2015 version of the statute. This, and it wasn't in effect at that time, back in 2004, when he was granted the pardon. So what counsel is saying that we can ex post facto apply the 2015 law to my client, which is untrue.
Your Honor, may I briefly respond?
Yes.
I am making reference to Article 42.12 that was in effect June 13th of 2001, which contains this judicial clemency exclusionary language. I'd also like to point out that judicial clemency is distinguishable from pardon, which Mr. Robinson has not received.
All right, so first question, was it a pardon or was it clemency?
It was a pardon. It was dismissed.
Respectfully, Your Honor, if I'm informed correctly, a pardon is something that is issued by the governor. And this order was not issued by the governor. It was issued by the judge of the court to which he was assigned for that case.
It's called a judicial pardon.
That's not a pardon. That's judicial clemency.
And the Cuellar case resolved it. That's from the Court of Criminal Appeals. Okay, it's out of Bexar County. And they said that in that case, it cannot be used. And this is current with my client's case and the statute as it existed at that time.
All right, State, have you had a chance to review the Cuellar case?
No, Your Honor. However, briefly looking at it, it seems that that covers a felon to possess firearm offense, which has nothing to do with the judicial clemency language in 42.12 section 20 subsection B.
All right, so the state's argument is that your client's offense, past offense, is excluded from not being used in this indictment. He's saying that under Chapter 42, that DWI is one of those offenses that are excluded as far as whether or not it can be used for enhancement to provide jurisdiction to the felony court. And you're arguing that's not true?
I'm saying it's not true in this case because the judge allowed him to withdraw his plea and dismiss the case. And it works as an acquittal under Cuellar.
Then why does it say, and State, I understand your argument, but then why does the document say that it can be provided as proof
No,
if he's convicted of any criminal offense to the court? If someone is pardoned, then it doesn't come back as proof that you're convicted of an offense.
it doesn't say that it's proof. It's in her order. It just says that the judge could be informed of the existence of the prior judgment. It doesn't say it's proof.
No, it says, and what I'm reading, it says it is therefore ordered. And then towards the end, it says, he is released from all penalties and disabilities resulting from the crime of the offense, except that proof of said conviction. That's what it says.
Except proof of conviction.
Of said conviction shall be known to the court should the defendant again be convicted of any criminal offense. Now, I understand what the state is saying with regards to chapter 42, but defense, you haven't addressed the issue. The defense is saying that, the state is saying that chapter 42 has been in effect since 2001.
Yes.
The part of the statute, the part of the code that he's reading from. Your client's conviction of this offense was this looks like January 7th, 2022. So wouldn't chapter 42 encompass this, since this conviction occurred after? And
2002.
yes, and the order discharging him from community supervision was signed by a judge in 2004.
Or
And the conviction date, it looks like it's 2002. State is saying that code section 42 is from 2001.
that's when I believe that's when it went into effect.
So then if you agree that chapter 42 is from 2001 and that a state is saying that DWIs are not covered by the exhibits that you've submitted to me, then the state would be correct.
Well, it says the language that it uses is that the case was dismissed. And that the judge allowed him to withdraw his plea. So it is no longer a final conviction. So in this instance, the language of the judge caused it not to be a final judgment. And I think under those circumstances, under the Cuellar case, that means that it can't be used for enhancement of punishment in this case. It's not expungible according to the statute, but it can't be used for enhancement. And that's what Cuellar says.
All right, state, are you prepared to address Cuellar? Or do you need more time?
So, Your Honor, as far as I can tell, Cuellar is completely off the mark for this. That was a felon in possession firearm case in which the defendant's prior felony conviction was subject to 42.12 section 28 clemency. And the state argued that essentially 42.021A, 42 points. Sorry, Your Honor, I'm getting confused. 42.12 section 28 clemency should just be ignored so that the state could charge Cuellar with felon in possession firearm. And the Court of Criminal Appeals ruled that no, the state can't just ignore judicial clemency. That has nothing to do with the circumstances of this case in which a person purportedly received judicial clemency that the court by section 20's own terms, he never should have been able to receive because the court had no authority to issue it. And in this circumstance, what this court should do is to ignore that purported judicial clemency order for precisely that reason.
All right, any other argument?
That's all we have.
All right, just give me, if you'll step back, just give me 5 minutes.
Sure.
And I'll review the documents that you've given to the court. Gabriel Diaz. Counsel, have you received all discovery?
I don't know, but that I did, Your Honor. It's my first time, Your Honor.
All right. State, were you able to tender an offer?
Not yet, Your Honor.
All right, Ms. Ferguson. If you recall this in 30 days, state you're to tender an offer at that time. All right, y'all coming back on January 14th, just have a seat and the coordinator will get you a reset.
Thank you, Your Honor.
All right.
Take a seat. Okay, please.
That's Gabriel Diaz, and it's gonna be January 14th, if you'll let Ms. Ferguson know when she comes back. Brandon Trader. Who's the attorney for Brandon Trader?
I'm here, Your
Hi. And where's he?
Honor. He failed to appear today, Your Honor.
All right. Let me see if he has a PR bond. Deputy, could you make an announcement in the hallway for Brandon J. Trader?
Yes.
Can you tell me on Brandon Trader, was he given a PR bond? Or a commercial bond? And hi, Deputy, could you make an announcement in the hallway for Brandon Trader?
Traeger?
Trader.
Trader, gotcha.
Thank you.
Yeah. I appreciate you.
Hold on a second.
Your client may, I mean, it's a possibility your client may be in custody. Because I'm reading some of the details.
I asked the deputy.
Mhm.
They said that he was not in custody.
Okay. All right, court is calling 2024 CR 01075 State versus Brandon Trader. Could I have parties announced for the record for the state?
Andrew Harris,
Defense?
Winnie McClellan.
All right, this hearing was scheduled at 9 a.m. It is 10:58 a.m. The defendant has not made an appearance. Defense, have you had any contact with your client?
I have not recently, Your Honor.
All right, state.
Assuming that Mr. Trader is not in the state's custody, bond forfeiture and issue a penalty for his apprehension.
All right, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, you're welcome.
May I be excused?
Yes.
Thank you.
Ayana Hubbard. All right, is she out here?
She is here. Oh, no, she was here.
Oh.
We're set, I know the court wanted an announcement.
Mhm.
We're set for in Judge Carter's court tomorrow for agreed incompetency.
All right. All right, so then what I'll do is I'm gonna recall you back. Because based upon the nature of the offense, you'll probably be going to the state hospital. So I'll set you for February 18th.
Okay, thank you, Judge.
Yeah.
Oh. Yeah.
All right, on Hubbard, it's February 18th. Clinton Dixon.
Like.
Hello. Hi, all right. So where are we on these new cases and intake?
Must be.
Oh, just 1 second. I'll give you a chance, I promise.
The aggravated robbery is indicted, Your Honor.
Okay,
The possession case is not indicted. I don't have any more information about its status than that. Before making a plea offer to defense counsel, I would like to attempt to confer with the complainant on the ag rob.
all right. And just 1 moment. What is the cause number on the aggravated robbery, please?
I don't remember you.
2024 CR 0129476, Your Honor. If that doesn't pull it up, I have the PF number if you want that.
All right, let me just do this. You said 2024 CR 0129476.
Yes, Your Honor.
All right, let me do this.
Sometimes Odyssey doesn't pull it up by that number.
Mhm. All right, who is the attorney assigned to that? Are you assigned to that as well?
Yes, sir.
All right. And do you have access to the discovery?
Yes, Your Honor.
All right, and there's something you wanted to say?
I thought it was a regular robbery.
Oh, you'll have to talk to your attorney about that.
But I'm trying to just go ahead and do a plea deal.
All right, so here's the thing. You'll need to speak to your attorney about that. I'm not your attorney, so I can't step in and say, I'm going to work this out for you. Your attorney will have to speak to the state. What I'm going to do is I'm going to recall you back. And I'll recall you back for January 9th.
I was at least trying to be out for my birthday.
Oh, I'm sorry. We'll have you back on January 9th.
You with the VA about the police, so I can get out of here, please.
I'll be in touch with the.
All right, thank you. Alexander Rodriguez. All right, so what is happening on this case? It's the final discovery date.
Yes, the state just gave us, uploaded some mental health records for the complaining witness and also some notes that were taken during their.
All right, who's the prosecutor on Alexander Rodriguez?
I have to.
And actually, Judge, I think there were notes, interview notes, they are going to upload, have not uploaded at this point.
Judge, we had the interview with the complainant on Thursday. My advocate Marina was out on Friday. She's currently meeting with the victim right now, but we do hope to get those notes done by either today or latest tomorrow morning. As a practice, I like to give the defense counsel the notes of the interview so they have everything. I did provide Marissa on Thursday or Friday the Brady stuff, but I do want to still give them the notes. As for the records, the complainant did go to counseling. We did rush those records. We already received those records and uploaded them last week as well.
All right, and so there's no more outstanding discovery.
From my, everything, that's why we met with the complainant. We talked about the details, any news information I already have requested. So I don't expect there to be anything else.
All right, January 14th is your last discovery date. I will not have another discovery hearing on this case. And on that date, state should need to be prepared to make an offer.
Yes, Judge, although I think we already extended an offer, but I don't anticipate defense I think we rejected the offer, right?
It is my understanding my client is wanting trial.
All right, so it's going to be a quick turnaround for jury trial, but on that day, state if you are not planning on making a new offer, is that correct?
No, not from what we've already offered. And like I said, we will be getting those notes this week. I will make sure that happens.
All right, then on January 14th, if you have all of the discovery before then, which I'm being told it's just interview notes, then January 14th will be final discovery and plea deadline. The only way I'll change the plea deadline date is there's some different discovery that suddenly pops up.
Right.
All right. Thank you. Millard Cummings. Sure. All right, was an offer tendered?
Today, for the first time, Your Honor, we got an offer. My client would like some more time. I'd like one more setting to try to contemplate that offer.
All right, your plea deadline date is going to be January 9th. All right,
Thank you, Your Honor. Is that all we need?
you need to get a reset form. All right, thank you. Joe Manuel Hernandez. Hello.
How are you?
All right, how are you doing?
Christmas Day.
Merry Christmas, Happy New Year, Happy Festivus, Happy Kwanzaa. Hi. All right, state, this is criminal trial division.
Mr. Garrett.
All right. So are we complete with discovery?
Well, Judge, I don't know, well, I do know for the evading we are, but it's associated with the DWI that the blood has not been come back. Yeah, okay, that's a misdemeanor.
All right. And the misdemeanor,
It's a DWI blood
is it
discovery.
related to this case?
Yes, it was same.
It's the same incident, Your Honor.
Okay. All right, we'll come back on January 30th.
Thank you, Judge.
Thank you.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
Shelby Rodriguez. Who's the attorney for Shelby Rodriguez?
It was Amy Owen, Judge, but I think she stepped out.
All right, just wait for your attorney. Seth McDonald?
Your Honor.
Yes.
And also, if I could do 2 for 1, Joanne de Hoyos had Roberto Campos with the dismissal. It's the only case he had on the docket today.
All right, could I see the file on Roberto Campos, please?
I can bring Seth McDonald up.
Yes.
Yes. Seth, come on up. Thank you, Judge.
You're welcome.
And Mr. Campos was here. He's in the back gallery. He's standing. You can have a seat.
Okay.
Yeah.
Good morning, Judge.
Good morning. All right.
If I could give you an update.
Yes.
I know that this was set for sentencing. However, on December 5th, I approached and you signed an order to appoint an investigator. You
Yes.
already signed it. And the investigator needed to have it signed by him. I already had Seth sign it, initial it. The investigator's in the hallway.
Mhm.
I'm gonna hand this to the investigator and we should get the medical records soon. I hope so,
Okay.
very soon. Seth doesn't want to be here till, February. So whatever day we can come back for sentencing. I already checked with the state. They're okay with that, trying to get the medical records.
All right, I'll recall it for January 16th.
Okay, January 16th. Thank you,
Okay.
Judge. I appreciate
Thank
that.
you. You're welcome.
Thank you, Judge.
You're welcome.
Have a seat where you were.
But even though it was already assigned.
No, that was January.
Your Honor, may I approach?
Yes.
Yes.
There you go.
Thank you, Your Honor.
You're welcome.
Okay, thanks so much. I can.
Need to give this to Marty.
Oh. No. Thank you. Would you please give Arlene Gay for copy?
I filed when I, you know, people said, I didn't think any of the response to it.
Okay. Yeah. Accepts and fries. Please don't go to.
Fine. I know, I had to step out to a CPS Zoom real quick, so can I just go back to the stack? Pretty good chance. Okay.
Yeah.
The other one we just had.
Thank you. Okay, all right, thank you. Luis Mora? And then Amy Owen, who do you have?
Shelby Rodriguez, I apologize, I was like.
No problem, I'll call it after this one.
Thank you.
Good morning. All right, court is calling 2022 CR 2485, State of Texas versus Luis Mora. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Jay Moritz, Your Honor.
And are you Luis
Yes, ma'am.
Mora?
Sure.
Are parties ready to proceed on the motion to revoke?
We are, Your Honor.
Yes, Judge.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Are you the same Luis Joaquin Mora who was placed on deferred adjudication in 2022 CR 2485 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on April 14th, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4, in their county, Texas, the defendant Luis Joaquin Mora, the defendant failed to report to the supervision officer as directed for the months of January, February, and March 2024, violation condition number 4.
How do you plead to that? True or not true?
That is true, ma'am. Yes, ma'am.
Your Honor, we'll waive it.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I understand. Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. The court doesn't have a trial court certification.
Okay, they're withdrawing the motion. You're gonna go adjudicate? Okay.
Just
I'm sorry, Judge.
No problem.
By the way, congratulations on your YouTube channel.
I'm sorry, what?
Congratulations on your YouTube channel.
Thank you.
Oh, don't play favors with the court, okay?
I'm not there.
So here's the thing, and this is just for me to make sure that the legal system is transparent. The legal system should be transparent. Everybody should know what's going on
Yes, ma'am.
with the court system.
Yes, ma'am.
And this channel is through the government,
Of course.
through the state of Texas. It's not my channel.
No, okay, I understand.
right.
I understand it.
All right.
This is a revocation of your probation, okay? And if the judge revokes you, you do have a limited right to appeal. Yes, sir.
All right. So is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion, continue on deferred, extend the individual for 18 months. And then for DDRF. And then state ISF, the substance abuse track, should he not meet the criteria for DDRF.
All right, so why is he not reporting? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand. Why are you not reporting?
I had gotten a hypertension pulmonary lung disorder, and they kept me in the hospital for a month because I was going through a divorce. So then after I got out of the hospital, I got scared.
So when were you in the hospital?
If I'm correct, it was January, no, right after I was done reporting. Had to be June, if I'm correct. January, June, one of those.
So June.
I think it was June, yes, ma'am,
All right, so you were in the hospital
for a whole month.
for a
yeah.
month, the month of June.
Yes, ma'am. And then they wouldn't let me out. And then when I got out, I was so scared.
When did they release you?
It had to be around July.
All right, so you were
July
released
20
in July.
Like July 29th, if not almost the 30th.
All right, and so nobody's seen you since July.
No, ma'am. And I had gotten scared. That I'm not gonna lie. So I didn't report.
All right, this doesn't make sense to me that he's not reporting since July and he has a reason that he was in the hospital.
I understand, Judge.
So does anybody have proof that he was in the hospital?
Paperwork, but it's not with me, of course. It's I have it in my file works at the house.
Well,
I came from the jail. No, that's why.
no, who else lives at your home with you?
Well, I'm to be honest, I don't have a home. I just have my paperwork with a friend of mine,
Oh, who's the paperwork with?
Jessica.
Jessica who?
Jessica Ambrodos.
Right. You have her number?
No, ma'am, I don't.
Then how do you get in contact with her?
I was staying there for the moment. They're just like.
Oh, do you know the number to that household?
No, ma'am, she doesn't have a landline.
All right. So here's the thing. If he is saying that he was in the hospital, which I don't know if it's true or not, I need proof of that.
I have paperwork.
What he's pleading true to is not being in, not reporting January, February, and March of 2024.
All right. So
He's talking about being in the hospital in June, and he quit reporting because he got scared after that.
Yes, ma'am.
is probation here?
Yes, sir.
Yes. Any objection to the court reviewing the court summary?
Not from the state, Your Honor.
No, Judge.
All right, could I see the court summary, please?
And we're showing his last report date was December of 2023.
Oh.
So
okay.
I'm not sure if he's referring to June of 2023.
I think so. Yes.
And probation, why are you requesting DDRF?
For his substance abuse issue, and I'm not sure if he just completed, I think he completed a TAP evaluation in December of 2023, and they were recommending.
Based upon the UAs and stuff, Judge, he does have an issue with the controlled substance.
All right, I don't understand. I'm not going to continue. I don't think you're a good candidate for probation. In this court, I always tell people if they need help, let us know. You've been on probation since 2022. And for that time, you've been missing for well over a year. So the court is going to grant the motion, find you guilty. Would you all like to speak to punishment?
See the.
Probation, did he pay the $60 restitution for laboratory testing?
No, Your Honor. He's paid a total of $56.
All right, I am going to order the $60 restitution for laboratory testing. I'll order the therapeutic community. It doesn't increase the time that you're that you're in custody for this sentence. It will just be able to help you with any drug issues you may have. And it appears that you have drug and alcohol issues based upon the court summary. So have you all been able to discuss a time?
No, I've not discussed that with the state has a recommendation.
All right, state, what is your recommendation?
It's the $3,000, like 5 years.
All right. Defense?
Judge, it's a deferred case. On the criminal history, I didn't see anything. I don't see why. Well, first of all, all the reasons have been, there hasn't been any crimes while he's been out. He hasn't committed anything other than testing positive for the drugs that he's taken for the mental issues that he's got. And that's why he was with the dual diagnosis program to begin with. So I'm looking for the minimum of 2, Judge. If you are still going to sentence to prison, I would like to get him a treatment program to get him into something. But I don't think it fits the needs to sentence him to 5 years.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it?
No, ma'am, I don't think I have, I don't.
Well, so this is what has happened. So I've revoked you.
Okay.
And what that means is because there was not an agreement on punishment, then you do have a right to appeal. That right to appeal is limited though. It's limited to whatever the allegations were in the motion that you pled true to.
Yes, ma'am.
You cannot appeal and say, I'm appealing because I was on deferred adjudication and I shouldn't have been on deferred adjudication.
Yes, ma'am.
That ship has sailed. So you do have a right to appeal, but it's a limited right to appeal. Do you understand?
I don't understand that. May you please explain that to me?
All righty. So anyway, did you sign that document entitled Trial Court Certification of Defendants' Rights to Appeal? Is your signature on that?
Yes, ma'am.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal. Your attorney will explain that to you. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, so we're off the record. I'm requesting the therapeutic community for you. It does not increase the time that you're in custody, but it may help with any issues you may have.
Yes, ma'am.
All right, good luck to you, okay?
Thank you, ma'am.
You're welcome.
Appreciate it.
All right, Amy, who do you have again, please? Okay. All right, Shelby Rodriguez. All right, so today an offer is due.
Yes. Has been committed.
All right. All right, I'm gonna set this for a plea deadline date. And I'll set it for January 14th.
Yes, that's perfect, Judge.
All right, thank you. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Cody Salazar. Who's here on Cody Salazar?
Oh.
All right, just 1 second. We'll call you back, don't worry. Jose Lopez? Yes.
Jose Lopez.
That was
He's in custody?
he's in custody.
Yes.
All right.
Come up here.
Yes.
Okay. Jose, let's go.
Excuse me, person in the dress, the flowered dress, you're not allowed to talk to inmates. If you do, you will be sent from this courtroom.
Good morning, Judge.
Good morning.
Uh,
How are
Miss-
you feeling?
I am doing better.
Oh, that's good.
Yes, my wife took good care of me.
Oh, okay. All right, so what we need is a jury trial date.
Yes, sir. Yes, ma'am, at this time.
All right, how long do y'all expect this jury trial to last?
Oh, ag robbery, what, 3-4 days maybe?
All right, so which case are you all proceeding on first? You got the aggravated robbery, retaliation, and injury to the elderly.
We may be, we may not proceed on this case, on the injury to other case. I'm still
Okay.
trying to decide.
All right, so if y'all will confirm with Ms. Ferguson on a jury trial date.
All right, thank you, Judge.
All right, thank you. And then once you know the date, let me know.
All right. Still talking. Oh, okay. You know what I said?
March 4th? All right.
There was an incident with him at the court date a while ago.
Mhm.
He wants to apologize for his conduct. He had a bad day.
All right, no problem. Let me just tell you, I scrubbed my brain of that. So it's like it never happened.
I understand that, but just in my mind, I'm a adult, you know, and I shouldn't have had that like outburst or nothing like that, you know, like that's uncivilized, you know.
Mhm.
So like,
All right, well, I
I don't
appreciate,
matter what I'm facing, but still, like I wake up, that's all right.
well, I appreciate
Thank
your
you. All right.
apology. You're welcome.
March 4th, okay. Joseph Smith somewhere supposed to be on Zoom.
Oh, yeah.
I gave him the link.
Oh.
Oh.
Thank you.
Hello.
Hi, Judge. Sorry, you
Oh,
called
I'll-
my case. I was
All right, I'll get to you. What's your,
Cody Salazar.
all right,
Apologies.
no problem. Yeah, I am concerned about you and your cough. I'm gonna walk you to the doctor if I have to. Okay. And counsel, who is your client?
Cody Salazar, Your Honor.
All right, Cody Salazar. All right, State, were you able to tender an offer today?
We have not yet. We did talk about possibly an offer, but I haven't officially extended an offer. I think the defense wanted some signed information he has that I don't have.
Good morning, Judge.
Good morning.
Last time we were here for discovery, there were some notes that I was able to review from the state today.
Mhm.
I'd like some time to absorb them. I also received some documents in my office Friday, which I have not had the chance to look over. And I would appreciate a little bit of time to do that. So I would respectfully request one additional discovery setting. And then we can take this from there.
And I think based on what he finds, and if he shares with me, that may also affect my offer. So that's why it's not official.
All right, January 30th is the last day. An offer will be due. And then after that, if an offer is not tendered, be moving into jury trial without one.
Thank you, Judge.
All right.
Appreciate you.
You're welcome. Thank you. Have a good one. You're welcome.
Have a seat over there.
No, discovery. Zion Taylor. Good morning. All right, what's happening?
Morning, Johnny, last time we were here, we had indicated to the court that we thought there was some discovery that was pertinent to the case that that the court allowed us to have an investigator.
Yes.
That he had uncovered. I've heard back from that investigator last week. He told me that he told me as to the progress of his actions. He did find a report. It's not, it wouldn't be something that would be flagged on this particular case through the DA's office, but we do believe that it's pertinent. He is in the process of subpoenaing the videos. They responded to us with a report, but not with the video. So we should have that subpoena ready by the end of the day or tomorrow at the latest.
All right, recall this for January 30th for discovery.
Thank you, Diddy.
All right, once you sign the reset form, you're excused.
Thank you, Diddy.
You're welcome.
Morning, Judge. Mary Butler.
Yes. How's it going?
It's going.
How's
CT
the
intakes.
leg and everything?
It's going better. I have 2 more months before I have my year checkup. Oh, sorry. If that goes well, then I get the screws removed.
Okay.
So.
All right.
Slowly but surely progress.
All right. Have a good one. No, I'll double check. Just give me a second. No, I don't have a paper file from McGarity.
Yeah. No, no, she. She's reported one of the. Yeah. Oh, if you need to come in the shop, I don't know if you were in the back. You look at the minutes. You have the board.
Hello. Yes, the deputy will show you. Thank you so much for coming.
I have two questions.
Okay.
Yes. Dinner time for open.
Yes.
Yes, thank you.
All right, if you'll call the attorneys, please, on the trial.
Yeah.
And wasn't she sitting on that end? Excuse me, sitting on that end too, correct? Yes. Okay. So you guys are doing both ends? Okay. State. Y'all review those. And just give me a moment. I need to put something in the system.
Okay.
Oh, so that's one.
Think about it. I think it- Yeah. Yep. There we go.
Yes.
Judge, can I see the?
Sure.
Thank you.
No, you're good. No, it's all right. It's for you, it's worth it.
All right, James McGarity. Who's here for James McGarity? Yes. All right, where are we on this case?
Judge, there is a video that I have talked to the prosecutor about that I do not have in my possession. She's working on getting that for me. We tried to do it today on a flash drive. It was not working, so she's gonna put it on a disc for me and get it to me this week.
All right, so you do have the video in your possession.
Yes, Judge, and it's on the e-discovery system. It's marked as discoverable, so I'm not sure what the issue is there, but Good did provide me with an external drive. And for some reason, it just wasn't compatible to upload on there. And so it is in my possession. I plan to turn it over this week. Here we go.
And I'll look on e-discovery again, but I know we went through all the discovery and I don't have it at this point, so.
All right, Norma, if you'll set this for January 27th. And states you'll need to be prepared to tender an offer at that time.
Yes, sir.
All right, is there anything else?
No, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. You're welcome. And what page is he on? All right, thank you. Casanova, Richard Casanova?
Yes, sir.
That's another one that we said. Watch your step. Someone here in the middle, we're going to speak on it here when spoken to, sir.
All right, so on this case, let me see. The jury found him guilty and he's coming to the court for punishment.
Yes, sir. Applied for probation.
All right, thank you. All right, court is calling 2024 CR 0073660-2, State versus Richard Casanova. Can I have parties announced for the record for the state? Defense?
Michael Collins, attorney for defendant, present ready, Your Honor.
And are you Mr. Casanova? All right, he was found guilty on December 4th
Yes, sir.
by the jury. And he elected to have the court assess punishment. The PSI was waived by defense in the state. Is that correct?
Yes, sir.
I need offensive, wait, yes, I have no objection to moving forward now.
Okay. And so we set it for this time for anyone to present any evidence or if they had any witnesses.
We have no witnesses other than my client, Your Honor.
The state criminal witnesses are we are going to admit, impact into evidence. Moving, Clemency Exhibit 1 and 2 for the sentencing.
Objection.
We are also gonna ask the court to consider all the evidence that was admitted in the evidence.
All right, states exhibits 1 and 2 are admitted without objection and they appear to be judgments. Any other evidence, state?
No.
All right, defense, any evidence?
Just argument, Your Honor.
All right, did you want to call your witness or no?
Let me ask him if he wants to speak, Your Honor.
Okay, sure.
Yes, on, yes.
Yes, Your Honor. I would call my client.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Richard Thomas Casanova.
All right, do you want to ask questions or is there something
think he wants-
specifically he wished to say?
Richard, do you want to address the court at this point about the punishment phase?
I just want to say that when I get out, I'm not going to go back to my mom's house or my daughter's, and I'll go to Hayden Furlough. And I wasn't aware that I couldn't go, to try to get my mail. I thought that the protective order had expired because it was 1 year. And I could never get my mail, so I didn't know what was going on. I was put on the street pretty much. I didn't have no place to go. So.
All right. Any questions? All right. So what I can tell you, Mr. Casanova, the fact that you're telling me that you didn't know about the protective order, that is what's considered as mitigation evidence. These type of offenses are sort of like strict liability. Was there a protective order in place? That's either yes or no. And did you violate it? Yes or no. So that's the way these type of charges are. There are some charges that are slightly different, but not this. Okay?
Yes.
All right. State, what are you requesting for punishment?
Given the history judge and the fact that it's not the first violation of protective order we asked for, here's to the scene.
All right. And defense, what are you requesting?
Would be requesting probation in light of he's been incarcerated since the date of the offense, which was late April of 2024. Your Honor, hasn't been in trouble with jail. And he is expressing to the court that he has no intention of going back there, Your Honor. He was under what he thought was a mistaken belief of fact.
I do have one thing to add. He was indicted as a repeater. We're just gonna ask for the judge mind touch from that.
All right. So let me see the indictment. And you're proceeding on the repeater enhancement allegation?
Yes.
All right. Mr. Casanova, you're still under oath. I'm going to read the repeat offender enhancement allegation paragraph, and I need to know from you if it's true or not true. And before you answer, you can discuss that with your attorney. It states, and it is further presented in and to said court that before the commission of the offense alleged above on the 24th day of June AD 2010 and cause number 2007 CR 2886 in Bexar County, Texas, the defendant was convicted of the felony of criminally negligent homicide with deadly weapon. So the question is, how do you plead to that? True or not true? And you can speak with your attorney before answering.
True.
Right. Then the court will find that true based upon your plea of true and based upon state's exhibit number 1. Now, what the court's understanding is that this location he went to, is that the daughter's house, mom's house, his house? It appears that during the testimony, he was saying that's his actual place of residence. I know sometimes when there are violations of protective orders that are filed, whoever they deem to be the offending party, they make them leave, whether their name is on the property or not. So the persons who were at the home, what I remember from the testimony is it was his daughter. Is that correct?
Correct, Your Honor.
Yeah, Judge.
So is this protective order involving the daughter, that location, and his mom?
Daughter. I would have to check to see if there's any other parties that are protected, but I believe it's.
That's the only one that was under protective.
So here's my question.
Daughter and the rest, and that address.
Yeah.
So here's my question. Has anyone spoken to the daughter?
So I can inform the court of what the daughter told me, but of course I don't know how.
Well, do you want to speak to the attorney before?
Let me
Yes.
just give me like 30 seconds.
Sure.
On the record, so I did speak with the complainant one time after one of our investigators went over to the address to make sure that somebody was present. We have called her multiple times, texted her, she had not returned her calls until one of our investigators went to the location and found her. She called me, I spoke with her. I did explain to her about the case, about being in trial, and her coming over to present her testimony, and she did indicate to me that she did want to testify. However, she could not make any arrangements because she is the caregiver of her grandparents.
Mhm.
And she could not make coming to court for that. We did make efforts to reach out to her over the phone. We confirmed that that was the correct number that we had. And after the guilt innocence, we did try to inform her about her coming over to testify during the sentencing, but she has not returned our calls. I have not sent out an investigator to her location again.
All right. So part of the consideration the court takes into consideration, or evidence that the court takes in consideration, especially in this case, one, of course, is protecting the community, and two, protecting the parties of the protective order. Now, sometimes family relationships between fathers and daughters, fathers and sons, mothers between their children as well, it's difficult. So what I would like to know, if it's possible, if it's not possible, I'll make my ruling without this information. But if y'all want to just try again today, state you and the defense counsel to reach out to the complainant, find out if she has any fear of him, and you know, what her thoughts are on sentencing. And then I'll make my ruling, but I'll make my ruling today.
As long as I can be present on the conversation.
Yes.
If we aren't able to get a lawyer today, I just want to make sure with defense, if you have any objections, we can bring it over Zoom.
No.
Okay. All right, let's try to do that. I want to make the right decision on punishment, okay?
Caveat, I'd like to be able to handle it sometime today because I start vacation.
No, we're starting it today.
I just.
So it's gonna happen
Okay.
today. If she
I was gonna-
appears, she appears. If she doesn't appear, she doesn't appear.
Can we have 5-10 minutes?
Sure. This is just information I would like to have.
It's fine.
All right, thank you. All right. Sheet of paper that just came through, please. All right, we're gonna go on the record in 2023 CR 4707. Can I have parties announced for the record in the state of Christopher Morrison for the state? Defense?
Shannon Locke for Christopher Morrison.
And are you Mr. Morrison?
Yes, ma'am.
All right, the court has received 2 questions from the jurors. State defense, did you have a chance to review those questions?
Yes, Your Honor.
Yes, Your Honor.
All right, the questions are, can we find guilty / innocent on the 3 different levels? Aggravated assault, deadly conduct, or assault? The next question is, do we have to have the same verdict for both counts or victims? The court will give you a choice if you all can agree. The first supplemental answer could be to both. The answer is no. If you all want me to answer it directly, otherwise, the answer will be, you have all the evidence and all the law, because the answers to their questions are located within the charge itself.
Yes, Judge, and so.
I think that so I think the court can direct them to the specific.
No, my question is, I'm not going to direct them to the specific. That's their answer, or either the answer is you have all the evidence in the law. Or actually it should be, or either you have all the law. Because I think both parties know that the answer to their questions is no.
Well, the actual answer is that if they cannot agree or they have a reasonable doubt, then they move to the lesser.
All right, so this is what the court's answer is going to be to both questions. The court's answer is going to be with reference to your inquiry. You have all the law before you. Please continue your deliberations.
It's fine, Your Honor.
I'm in
All
agreement.
right, any objection?
No, none from the
Any
state.
objection?
Your Honor.
Can I have those 2, please?
Yes.
Any objection to sending the questions and the answer back to the jurors, or would you all like the jurors to be brought back in?
I have no objection to sending it back.
You can send it back, Your Honor.
All right. Thank you. We'll go off the record.
Would you like this?
Thank you. All right, the parties on Araceli Robles. Okay. Oh, Mr. Morrison, you can step outside. Just make sure you're around, okay? All right, thank you. Jenna Rodriguez.
We're here, Judge, we're ready.
Okay. All right, do you know on this case, where is Jenna Rodriguez?
She's right here, Judge.
All right.
She's coming forward.
All right. On this case, do you know if the evaluation report, do you have that or not have that?
Yes, we've already done that, Judge.
And has it already?
We've accepted the results of the evaluation.
All right. And what were the results?
She was competent.
Okay. State, were you able to tender an offer?
Yes, Your Honor.
All right, Norma, if you can set this to the week of January 6th for plea deadline date. All right, January 7th. At that time, you'll need to let the court know whether you're accepting the state's offer. You understand?
Yes.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused. You're welcome. Johnny Joe Aguirre. Okay. All right. Does he only have the one case?
Yes, ma'am. He had an MTR and this one, Ms. Megan Cook represented him. He was sentenced, I think, 6 years last time we were here. So we're here on a discovery. Is my understanding.
Yes. So where are we on discovery?
I think we have everything, Judge.
All right, state, were you able to tender an offer?
They have, Judge. They have tendered me a couple different offers.
Okay. All right, then I'll put it for a plea deadline date.
Okay.
Are you available the week of January 6th?
I think I'm going to be out that week, Judge.
Okay.
Until the 13th I think that's a Monday. If I'm not mistaken, I will be gone until then.
Okay.
So I can't do the
Alright.
13th.
Ms. Ferguson, can you put this the week of the 20th, please? And of course, the 20th is a holiday, so anything after that.
Sure.
All right, 23rd.
All right. Thank you, Judge.
All right, thank you. All right, we'll bring you back on the 23rd. At that time, you'll need to let the court know whether or not you're accepting the state's offer.
Okay, thank you.
All right, you're welcome.
I have excuse, Judge.
Yes. Page is Johnny Joe Rodriguez on? Is he on the docket?
It's on the docket. I just can't find it.
Is he also Johnny Joe Aguirre?
Yeah.
Okay, alrighty, and make sure they don't send him. Taylor Kirchmeyer, or Kirchmere? Who's the attorney? All right, just have a seat, your attorney's not here. Lieutenant Araceli Robles? Oh, okay, all right, I'll take care of it. Laura Salcedo? Hi. Are you already on this one or no?
Yeah, I did.
Okay. If they have something they need to put in. It's the alternate. Yes. All right. And which alternate? All right. So if you will have the cleaning people come. All right, thank you. And then let me talk to the defense. If you all can step back briefly. All right, state. It's with regards to the jury trial. The court is going to release one of the alternates. They're ill. I'm assuming there's no objection because they're an alternate. Mr. Locke,
That's right.
where, could you have your client come in, please?
Nope.
Would you like us to move, Your Honor?
No. It's just one of those things. Yeah. We'll call the cleaning person. And can you put the other alternate in a different place?
Yeah.
All right, thank you. All right. We're going to go back on the record in 2023 CR 4707. All right, counsels, the deputy has just informed me that the alternate is ill. And so the court is going to excuse the alternate. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor. Which alternate is it?
All right. So you can excuse the alternate. All right, thank you. And the alternate is what was previously juror number 51. Okay. All right, thank you. You can step back outside.
That's right.
Rudy Gonzalez. Who's here for Rudy Gonzalez? Yes.
We're gonna have one set ready.
Okay,
And
sure.
then one more set, and I didn't know if we can go ahead and try to get it done real quick. or-
Yes, we can.
Okay.
Okay, thank you, Judge.
All right, you're welcome. You're welcome. And counsel, just give me a moment with your matter. Okay. All right. The last case I'm going to take up is going to be Studemeyer. Your case, sir, and Bridget Garza. I'm going to take your case up. Okay. And then the other people will have to come back for the afternoon. And the other exception to that is the attorney for the sentencing.
Well, our case will excuse.
No, I'm going to take it up. I'm going to give you your answer unless you're able to. Are you able to come back this afternoon, counsel?
Not really.
Well, then why ask? That's my thing. I don't understand what's happening today.
Well, if you're gonna make a ruling.
I'm going to make a ruling. Thank you, counsel. Counselor, if you would like to zoom in for the ruling, you can. I said, if it would help you out, if you would like to rule in for the zooming, you can. Zoom in, if you would like to zoom in. Okay. Could
I'm not
somebody
sure I
explain-
understand you.
All right, can somebody explain that?
Get on Zoom
this afternoon.
Zoom. Oh, you're saying Zoom. I didn't understand what you were saying.
Was I not saying that correctly?
Did say rule in to zoom in.
I'm like, all right, so yes, if you would like to appear by Zoom for the afternoon, you can. So would you rather appear by Zoom this afternoon, and I will give you my ruling?
Are you capable of doing it now?
I am busy right now.
Then we'll do it this afternoon.
All right, thank you.
Speaking of Zoom, Judge, I've got Joseph Smith online. If you want us to come back at one.
No, he's not on,
Yeah,
he's not here, but if you could come back at 1:30, that would be appreciated.
He didn't log on?
No. Zoom. It's been a crazy day today.
All right,
People are
figure
sick.
that out.
Yes,
Judge, will you be available to be approached off docket at the 1:30 docket?
yes.
Awesome. Thank
All
you.
right, thank you.
What time is the Zoom?
She called up and then back now.
The Zoom, what time is it? 1:30?
And then I don't know why this equipment is not working either. This is off, so I can't even. Can you reboot that, please? Somebody, I think, touched that. All right, let me take care of that.
Link.
Like Monday on steroids.
The judge calls my client here, Kirchner, while I was in the hallway.
Yes.
Kirchner, yeah.
Yes.
Can we approach on that? Which,
Yes.
it's a PTD application. We've turned in the signed contract. I put in another email today to Lucy Salinas, in charge of PTD department. I haven't heard that. Where the
All right, Kirschmeyer, if you'll come forward.
Taylor?
So you're saying you put in all the documents?
We put in all the documents, Your Honor, signed the contract, turned it in. And I put an email this morning.
All right, can I get a PTD date on Kirchmeyer, please? January 13th. All right, January 13th. Once you sign the reset form, you're excused. Thank you.
Thank you, Your Honor. Appreciate it.
You're welcome. Yes. Yes, I'm gonna recess in just a moment.
Oh, you are?
Yeah, just give me a moment.
Okay.
All right, we're back on the record with Mr. Casanova. This one moment.
Have a seat. Thank you.
Let me just grab your file.
Oh, okay.
Here we are. All right, we're back on the record and 2024 CR 0073600-02 State versus Richard Casanova. All right, State, did you have a chance to reach the complainant?
We have Judge Diaz, we have not successfully reached the complainant. Our victim advocate did come down earlier, and while defense was present, she did make 2 phone calls to the number that we have for the complainant. There was no answer. She did leave a voicemail, informing the complainant to call us back for the next 5 to 10 minutes. As the court asked questions, we did offer hearing over Zoom as a possibility, as an option, in the voicemail. She also sent a text message, but that was more than 10 minutes ago at this point, so we have not been able to.
All right, so and are both parties still wishing to proceed without the input from the complainant, State?
At this point, Judge, it's pretty clear that the complainant does not have any part of the session.
All right, defense?
We proceed without.
All right. So what I can tell you, Mr. Casanova, I don't think that probation would be appropriate in this case. I have to consider your entire history. It's not just this one incident. All right. So then the question becomes, the state is requesting 8 years. What are you requesting?
I request a minimum, Your Honor, 2.
Okay. All right. This is what the court is doing. The court is finding the enhancement true based upon your plea of true and based upon state's exhibits 1 and attachments. The court has heard all the evidence in this case. Based upon the evidence that the court heard, I understand the nature of protective orders, but it doesn't appear that from the testimony that the court heard that the defendant was there to be violent, that the defendant was there to cause a disruption. The only testimony that the court heard was that he was there to collect his mail. And the testimony that he gave sounded believable to the court and sounded credible, because otherwise, why would he just be waiting, if not to pick up his mail, as he said? But we're not allowed to be at the residence. You understand? All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served. Let's see. All right, I don't have your trial court certification in here. You may have filled it out, but it is not here. So do you mind filling out another one? For
Yes,
the
sure.
court? And then I'm also, as a part of your sentencing, I'm going to order no contact with let me see. I don't have the state's exhibits here. Who was the,
We're still with a C, Casanova.
there's to be no contact with Crystal Casanova. Do you understand?
Yes, Your Honor.
That's from here till eternity. Now, if she decides that she wants to see you, then you all will need to file motions with the court and ask that that be removed. Do you understand?
Yes, Your Honor.
So any location where she may be, you're not allowed to go there. Do you understand?
Yes, I do.
Whether it's your house or not your house. If it is your house and you feel as though you have a right to be there, that's something that needs to be settled in the court of law. That's not something where you just show up.
Yes.
You can't show up for your mail. You'll need to go to the post office and ask them to change your mailing address. Do you understand?
Yes, Your Honor.
All right.
Sure. Sign. This is says you have a right to appeal if you'd like.
Yeah.
All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
I understand.
All right.
That's-
This is a jury trial, so you do have a right to appeal. We can go off the record. If you wish to appeal, your attorney will know to file the notice. And if you cannot afford appellate counsel, one will be appointed to represent you.
Okay,
All right. Good luck to you, sir.
thank you, Your Honor.
You're welcome. Counsel,
Thank you.
you're welcome.
And excuse, Your Honor.
Yes, you may be excused. And Norma, if you'll order lunch for the jurors, please.
Grab some lunch downstairs, Judge.
I'm sorry, what?
Can I grab some lunch downstairs?
Sure.
Is there,
Yeah.
will you not be accepting a verdict until a certain point, or
No,
if they
as
called you? right
whenever
now?
they call, they
So I'm
call.
just in the cafeteria.
All right, sure. They'll send you a text message.
You can come back at 1:30 and my students. You can come back at 1:30.
Number recall Robles on January 7th.
He wasn't. But then when he in contact.
Yes. Yes. Mhm.
And then.
Okay. All right. Well, we'll see if we can get in touch with her attorney. Thank you.
And then.
We're gonna try to get in contact with you. Yeah, I would treat, so I need to make sure the gender colors.
Yeah.
I mean, you know.
Cindy, it's almost like it was a full moon and it's still a full moon now. All right, Rudy Gonzalez. All right, thank you. And there, and probation, you can be excused. There are no applications on this case. You're welcome.
1:30.
Well, 1:30-ish. Ish, yes.
Mr. Gonzalez is just restored, Judge.
All right. Good afternoon, or, yeah, good afternoon.
Good afternoon.
How are you feeling today? It's not a true question, I promise.
It's a lot better,
Oh,
I
that
gotta
is good.
say.
Yeah.
All right.
All right. All right, court is calling 2024 CR 4541 and 2024 4494 State versus Rudy Gonzalez. Can I have parties announced for the record for the state? Defense,
Bridget Garza.
and are you Mr. Gonzalez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And each cause number, Mr. Gonzalez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 4-1, are you proceeding on the indictment as presented?
You are, Your Honor.
And in the cause number ending in 9-4, are you proceeding on the indictment as presented?
No, Your Honor. We're waiving count 1 and the enhancement paragraphs and just proceeding on count 1. Can I say count 1 in the first one?
Yes.
Waiving count 2.
Okay,
I just realized that step right there. And proceeding on count 1. And that's the third degree theft, 30,000 to 150,000 vehicle, Your Honor.
all right, any objection?
No objections, Your Honor.
All right, and the cause number ending in 4-1, you're charged with burglary of a habitation, and the cause number ending in 9-4, you're charged with theft, 30,000 to 150,000. Those documents that have those charges in it, it has in there your rights and certain things that you're giving up by entering the plea bargain agreement in each of these cause numbers. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places? All right. And the cause number ending in 4-1, the range of punishment is 2 to 20 years. And the cause number ending in 9-4, the range of punishment is 2 to 10 years. If you have a plea, I don't have to follow that plea. If I don't follow your plea and give you more than you bargained for, you can withdraw your plea. And this can be set for trial. Do you understand? Do you understand in each of these cause numbers, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering these plea bargain agreements, you were giving up those rights? And did you intend to give up your rights and enter into a plea in each of these cause numbers? Did you intend to give up your rights and enter into a plea bargain agreement?
Yes.
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does now, Your Honor. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
And it's the court's understanding that competency was restored?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you to get you to enter a plea in these cases? Anyone coerced you or forced you to enter into these pleas? All right. Anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
I'm satisfied. Yes, ma'am.
All right. Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause number ending in 4-1, according to the agreement, punishment is to be assessed at 8 years. There's a $2,000 fine. This will run concurrent with the cause number ending in 9-4. There's going to be restitution to Venkata, Venkati, Lecareddy, Lakkireddy of $500. The state will take in consideration 2024 CR 4493, 4066, and 2023 CR 7253. And the cause number ending in 9-4, according to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. And this is running concurrent with the cause number ending in 4-1. And there are no applications in either of the plea bargain agreements. Did you understand that to be your plea?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
All right, then in cause number 2024 CR 4494 to count 1, how do you plea? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And then in cause number 2024 CR 4541, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Your Honor, in each of the cases, state exhibit that all involved with that.
Any objections?
No objections, Your Honor.
And each cause number, did you review a document? And that document is the stipulations. It has the police reports in it. It has witnesses' statements. Basically, the evidence that the state is submitting to prove you guilty beyond a reasonable doubt. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
All right. You do understand that you do have a right to a jury trial. You understand that? All right, so that would mean that witnesses would come in, the state would call witnesses, and those witnesses would testify, and your attorney would get a chance to ask them questions, and nobody could force you to testify. Did you understand? So today, the state is just going to present those witnesses by presenting statements that they've given to the police and police reports. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I've been representing Mr. Gonzalez for over a year. And now that he's been able to get some treatment for his mental illness, he's had a clear head. He's pleading guilty because he is guilty. He is remorseful. He takes responsibility. And he wants the court to follow the recommendation of the ADA. He does have a drug problem. He recognizes that. And he understands that when he's in prison, he's gonna have time to reflect on the poor choices that he makes. He's gonna try very hard when he gets out to try to stay off the drugs that caused him to be before the court. And so he's asking the court to follow the recommendation of the ADA.
All right. All right, and the cause number ending in 4-1, the court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2024 CR 4494, taking consideration 2024 CR 4493, 4066, and 2023 CR 7253. There's to be restitution in no contact with Venkata Lekareddy, and the restitution amount is $500. And I'll order the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but it may be able to help you with any issues you may have. Do you understand?
Thank you. Yes, ma'am.
You're welcome. I can't force you to be in the program, and I can't force them to put you in the program, but they'll see on the judgment that I'm requesting it. You'll still have to ask for it. You're welcome. And the cause number ending in 24. The court will follow your agreement. The court will find you guilty as previously stated, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 4541, and I'll ask for the therapeutic community. Is there anything else with regards to sentencing in each of the cause numbers, state or defense?
No, Your Honor.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition, If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Make sure that you ask for the therapeutic community. It's there to help you. Like I said, it's not going to increase the time that you're in custody. If they are planning on releasing you in 2 years, they're not going to say, oh, he hasn't finished therapeutic community. Let's not release him. That's not the way it works. And when you're released, if I'm still here and you can't find a place to stay or you can't find, Center for Healthcare Services, just come in and I'll pick up the phone and call somebody, okay?
Yeah.
You can't stay with me, but I'll find a place for you, okay? All right, good luck to you, okay? You're welcome. Have a good day.